When a franchisee seeks to exit their franchise agreement, we have to take a very careful look at what that agreement actually says. Agreements should contain language that would allow the franchisee to terminate in the event of a breach by the franchisor. Sometimes they describe that as a material breach. So what actually is a material breach? And then another thing that we have to look at is when the franchise disclosure document was provided. Were there representations made in that document as to what the franchisor was going to provide for the franchisee? And so identifying the requirements that have been placed on the franchisor based upon the representations made in the franchise disclosure document and those contractual obligations that are set forth in the franchise agreement itself. I always advise clients on the front end to talk to other franchisees and what are the other franchisees' experience with this franchisor, because a lot of times they'll get in and find out that the costs are much more than what was originally represented. And so this is something that helps us get out based upon a fraudulent representation that was made by the franchisor on the front end. So each one of these turns on its own particular facts and circumstances, and each one requires a careful analysis of the franchise agreement itself. What are the terms and provisions that agreement provides for exit? And then the franchise disclosure document. What representations were made on the front end, and did those representations turn out to be false?